Let's go. What up, Doe? This your boy Tay Biz, man. What's going on with everybody? How's everybody doing on this lovely 3:00 afternoon here in America on the Eastern Standard Time? Appreciate everybody rocking in and joining in real quick. We got a few things we're going to discuss today. We got a couple motions I want to go through real quick. You know, it's Motion Mania down there in Georgia. You know, the motion hearing is next Tuesday, July 30th, and your boy will be broadcasting it live next Tuesday, so don't miss it. I want to go ahead and look at the chat real quick. I got Felicia Fee in the building. What up, Doe? Saying afternoon to everyone. And of course, the lovely Abundance and Clarity 82 saying, hey, everyone, please hit the like button as you come in. So we are here, man, to have a little bit of a discussion. Talk about a couple of these motions. There's a lot of motions. Let's just be real. There's a lot of motions that have been filed on the defense side for sure. Obviously, because there's more defendants, six defendants, but also a couple of responses from Adrian Love. She filed a response today for a motion to deny Brian Steele's motion for the factual findings of the case after the recusal of Judge Glanville, and the fact that Judge Krause stated that she did not find anything improper in the ex parte meeting, which is absolutely wild. So it's a lot going on right now. All right, it's a lot going on in Georgia. But before we do that, I want to go ahead and first send another shout out to Maggie. Thank you again. We did an interview last night, and it was a beautiful interview. We understood what a femininity coach was, and we understood some of her ideologies on what's going on in the dating culture and what's happening when it comes to relationships and things between men and women. So we definitely want to say thank you to Maggie. And I also want to shout out BLJ, the General, who gave me my first 2 super chats of a nice, substantial amount. And I really do appreciate the support in that regard. So I also want to give it up and clap it up for him as well. So hopefully he sees this and uh, and we'll say something in the comments and things of that nature. So Abundance says yes, Miss Maggie was amazing. Absolutely was amazing. Her presence, man, it's like she's very graceful, and speaking with her and talking to her, you find that she has a balanced point of view, but again, traditional, as I like to call it, virtuous points of view as well from the woman's side. And a lot of times we hear all the bad B side. We hear the my body, my choice side. We hear that all the time, which is, hey, that's how you rocking. That's how you rocking. Ain't nobody knocking that, but don't knock the ladies that want that traditional, homegrown, authentic relationship either. You can't knock the ladies that want that. So, again, shout out to Maggie, substitute teacher. I appreciate you once again. All right, we about to go ahead and get started. We're about to go ahead and get started, man. I want to first, because I want to highlight. I think I want to start highlighting like certain attorneys and their moments in the YSL trial. I think I'm going to start doing that this week. Today I want to talk about the Silver Fox. You know what I'm saying? And we never get a chance, or a lot of people don't talk about Careton Matthews Sr., who is the attorney for Marquavis or Quay Huey. And I came across day 2 of the trial where he did his opening statement, and I was like, the first 5 minutes, I'm like, man, this dude is on point. And so I wanted to highlight his moment in the case and in the trial as well, with his opening statement that he did on day 2 of the trial. So we're going to go back and just check out the Silver Fox and his team, and his demeanor, his professionalism. And there's a lot of times where he will cross-examine certain witnesses, especially those investigators and things like that, detectives, and he would be spot on with his questions. So I definitely want to highlight him today. But before we do that, I want to go ahead and look at a couple of motions here. And the first motion I want to look at is the motion. Let's go ahead and do this real quick. There's a motion that Brian Steele did to renew the bond of your boy Young Slime. And I want to talk about that real quick. I want to read that real quick. Y'all can y'all see that there? Can y'all see that there? Let me go ahead and highlight it like that here. Hope y'all can see that real quick. Put a 1 in the chat if you can see that real quick here. This motion is to renew the bond and brief in support of pre-verdict bond. And so when we look at the pre-verdict bond, it's the method to release a defendant before the trial, or get him out of custody before trial, because he has not been found guilty yet. And if he hasn't been found guilty yet, then Steele is like, why are you have my client in custody? And so I want to go ahead and take a look at this and read this real quick. Sorry, because it's like a 10-page, filing here. It was filed yesterday at 5:22 p.m. And so I know a lot of other people jumped on it and started going live about it and things of that nature, but I wanted to also incorporate this and highlight Careton Matthews. She said, "What up, though?" Look at that, though. What up, though, is in the building, man. All right, let's go ahead and do this. It says here, this is the state of Georgia versus Young Thug right here. And this is a renewed motion for bond and brief in support of pre-verdict bond. It says here comes now defendant Jeffrey Williams, by and through undersigned counsel, and hereby files the renewed motion for bond and brief in support of pre-verdict bond in the above referenced case. In support of this renewed motion for bond and brief, Mr. Williams shows the below. It says here, in the great state of Georgia, unlike other states, for purposes of pretrial bond analysis, the presumption of innocence remains with the person accused of an offense, even a capital offense, from arrest and even during trial. It says here that means prior to and during trial, courts view the criminally accused to be innocent of the charges waged against him or her. It has been written that the most fundamental premise of our criminal justice system is that the criminally accused cannot be punished for an offense until the prosecution proves guilty beyond a reasonable doubt. Okay. It says here, thus, the granting of a reasonable pretrial bond must be preserved. Otherwise, the presumption of innocence, secured only after centuries of struggle, would lose its meaning. And he cites another case and says here, in the order to protect our firm foundational belief that the accused is presumed to be innocent prior to a finding of guilt beyond a reasonable doubt, the prosecution alone has the burden of persuasion in convincing this honorable court that there are no set of conditions or circumstances that can be ordered to permit Mr. Williams' pretrial release on bond. So basically saying here that you have no actual proof or no type of burden of persuasion and convincing the court that, he doesn't deserve a bond at least, and so, which was kind of, I would say, a little bit telling is the fact that the bond was denied in the first place, So it says, let's continue here. It says here the state bears the burden of proving by clear and convincing proof that pretrial detention is warranted. This requires the prosecution to carry the burden of proving by preponderance of the evidence that this honorable court must deny Mr. Williams' motion for bail outright rather than set bond with conditions of same in order to ensure Mr. Williams' presence in court and to protect the community. So basically, you got him in jail because you think he ain't gonna come to court, but he will. It is so significant to deny Mr. Williams' pre-verdict bond that the Honorable Supreme Court of Georgia requires this court to specifically explain why no bond could be set. Explain why no bond could be set. All right. So our higher courts can evaluate whether there was a flagrant abuse of discretion when reaching that decision. When considering pre-verdict bond, alleged guilt is extraneous, is completely irrelevant, and not considered for the pre-verdict bond analysis, as supposed guilt has no place in the bail proceeding since Mr. Williams is presumed innocent. Okay. Here cites a couple more cases. So it says, our highest court explained that in a bond hearing, Mr. Williams bears the initial burden to produce these particular things right here. Now, let's get into this because these are the things that have to be proven that a defendant will do in order for a bond to be dismissed or denied. Right? So that's why it says our highest court explained that in the bond hearing, Mr. Williams bears the initial burden of producing evidence that he would not pose a significant risk to flee the jurisdiction and would return to court when required. This is a very, very important statement right here. I want you to keep this statement in mind, okay, as we continue to read this. It says not to be a significant threat or danger to the community or to any person or property. Now, put a 1 in the chat if you think he would be a danger to the community or significant threat to the community. Put a 2 in the chat if you do not think that he will be a significant threat or danger to the community or to any other person. Okay. Number 3, not to be a significant risk to commit a felony while on bond. So he has to prove and show that he will not be a significant risk to commit a felony while on bond. Not to be significant, not to be a significant risk to intimidate witnesses or otherwise obstruct administration of justice. All right. So these are the things right here that the defendant bears the burden of proving and showing that I'm not going to do these things. I'm not going to be a flight risk. Okay. I'm not going to flee the jurisdiction at all. I'm going to come to court. I'm not a significant threat or danger to my community. Okay. I'm not going to do anything to anybody. I'm not going to commit any felonies while I'm on a bond. I'm not going to do any type of intimidating witnesses and threatening people. I'm not doing any of these things. Okay. So Brian Steele is going to go down each one of these things and explain why. So Mr. Williams is not a flight risk. To meet this burden, Mr. Williams must first present evidence showing his roots in the community, which would include the length and character of residence in the community, employment status, and past history of responding to legal process. Mr. Williams was born and raised in the Jonesboro South section of Atlanta, Georgia. Since birth in August of 1991, man, he young. Mr. Williams has maintained residence in Atlanta, Georgia. Although Mr. Williams has traveled the globe, has performed his music and artistry in every continent, save Antarctica, he always returns to his homes in the Atlanta, Georgia area. In fact, days before the return of the original indictment and the arrest of Mr. Williams returned to Atlanta, Georgia from the country of Norway. Mr. Williams is one of 11 children, and he is the father of 6 children, ages 16, 13, 12, 11, 9, and 9. All of Mr. Williams' family lives in the Atlanta, Georgia area, including his parents. There is not many among us who has stronger roots in our community than Mr. Williams. Now, remember we had this. Remember we looked at the video of Brian Steele and the interview with the news lady, and how he presented Young Thug in such a light that even you would want him to be your lawyer. Remember we talked about that? Okay. He's doing it again in this motion. He's letting you know that Mr. Williams is he's not a flight risk. He's not going to go anywhere. Okay. He's not going to do anything. All right. He lives and breathes Atlanta, Georgia. Mr. Williams has been working since he was 6. At age 14, he was recognized and began performing his music for audiences. As a teenager, he had a manager, and within a few years, Mr. Williams was signed by Atlantic Records and was paid $1 million. Mr. Williams is currently gainfully employed, tirelessly works at his artistry and other lawful business ventures that include clothing lines, modeling, owner of a successful record label, and various investments. Mr. Williams has demonstrated a strong history of lawful employment. Now, this is why I did the highlight real quick. Because now I'm starting to smell an offer. When I read this, I was like, wait a minute, I'm sniffing something here. It says here, Mr. Williams has appeared in courts in the past, presented by undersigned counsel, Brian Steele, for approximately a decade. Remember, he said that. He said, to wit, Mr. Williams' entire adult life. Mr. Williams has never missed nor been late for a court appearance. Mr. Williams has a history of responding to the legal process. Watch this. Listen to this. Undersigned counsel is in possession. So Brian Steele is in possession of Mr. Williams' passport and has the permission to surrender this passport as directed by this honorable court for purposes of bond. Okay. So in other words, if you want to make sure that he will not do anything for flight risk or anything like that, I have his bond, I have his passport, and I have the permission and the power over his passport to do whatever I want with it, including render it over to you, Judge. I love me some Brian Steele, man. This dude is awesome. Okay, he is awesome. He is awesome. Furthermore, when a bonding company writes a bond for the criminally accused, that company takes financial risk in ensuring the criminally accused presence is in court. In the case at bar, Free at Last Bonding Company has agreed to write a bond set by this honorable court, and the representatives of Free at Last are motivated to keep track of Mr. Williams and prevent any possible flight. So in other words, again, they are willing to work with us and making sure that, okay, I'll give over the passport and they will set the bond, and you can also track him if you want to. All right. You can also track him if you want to. Okay. Very interesting. Very, very interesting. Okay. Says here also, let me add real quick here. Mr. Williams intends to present witnesses to testify at the renewed bond hearing. Okay. And it says right here, the footnote is Mr. Williams respectfully requests a date certain to argue this renewed motion for bond so that out-of-state witnesses can be present to testify before this honorable court. So, he knows a lot of people in the industry, right? So, a lot of people could testify on his behalf, especially if he's not a threat like Mr. Williams is saying. Specifically, Mr. Williams' parents, managers, members of his record label, childhood friends, business associates, and the like will be present in court to testify and show support for the granting of pre-verdict bond for Mr. Williams. So what does that mean? What are these witnesses called? They're called character witnesses. Character witnesses. They're going to explain the character that, he's not who you think he is. He's an entertainer. He's not trying to be a flight risk. He's not trying to be a felon and do all this gangster stuff. He ain't really trying to do all that like that. You know what I'm saying? So basically what they're saying is, look, we know that he's okay. We know this. So you don't have to worry about anything with this. We got leverage. We got some collateral. We got some leverage. Mr. Williams is not a significant threat to the community or any person in the community. Mr. Williams has taken the initiative to secure the commitment of full-time off-duty sworn law enforcement officers to watch his home and secure him in his home 24 hours, 7 days a week. This is the offer. Okay, now we getting into the actual offer. All right, that we willing to, if you give us this pre-verdict bond, we willing to give something to get something here. All right. If house arrest is ordered by this honorable court as a condition of pre-verdict bond, okay, Mr. Williams will also submit to wearing an ankle monitor if ordered by this honorable court as a condition for bond, pre-verdict bond. Mr. Williams will submit to a condition that any person who would visit him at his abode would have to be on an approved list provided by this honorable court, as well as the DA's office. And if the individual's name is not on the list, that person will be denied entry in the home. They are getting into the details. They are getting into the offer. Go ahead and like this. Go ahead and like this stream and share this stream. All right. This is amazing. This is not a bad offer, though. I ain't gonna lie. I'm not gonna lie. The judge got to really look at this for real. This is not a terrible offer, man. Oh, man. Okay. Even visitation, even down to the visitation, he like, if you want to control that, that's fine. Mr. Williams will submit conditions. Says here, moreover, any visitor will have to consent to being searched physically and electronically by the off-duty sworn police officer. And if the visitor does not agree to consent to this search, the person will be prohibited from visiting with Mr. Williams. Wow. Mr. Williams also agrees that any of his text messages, telephone calls, emails, or other forms of communication in any manner can be secured, and the information provided to this honorable court, if desired, as if Mr. Williams was in custody and on a recorded line. Who does this remind you of? Hold on, let's talk about this real quick. Y'all remember Pablo Escobar? Put a 1 in the chat if you remember Pablo Escobar. What happened? He went to prison in his own mansion. He imprisoned himself in his own mansion. He still is trying to give your boy the same deal, if you will, as Pablo. As your boy Pablo, okay? Wow, man. Emails and everything. It doesn't matter. I'll give it all over to the court if desired, as if Mr. Williams is in custody and on a recorded line. The cost of the 24-hour, 7-day-a-week off-duty sworn police officer detail, as well as the cost of the ankle monitor and any other related costs, would be incurred by Mr. Williams. With these parameters in mind, it cannot be said that Mr. Williams would be a threat or danger to the community or any person or property in the community. Undersigned counsel will agree to meet with Mr. Williams at his home to continue to prepare for his trial. In other words, I got to be on that list now. If anybody gonna be on this list, it's gonna be your boy. It's gonna be Steele. All right. The above conditions place Mr. Williams in custody in his home. He cites a case here. Specifically, our General Assembly has provided for the creation of electronic pre-verdict release to assist sheriffs in alleviating jail overcrowding by creating alternative methods of pretrial release, monitoring, and home confinement. Remember we talked about the fact that the Fulton County Jail is supposed to have, I think, about 1,000 man or 1,000 body limit. It's more people in there than not. It's over 2,000, almost 3,000 men in jail, in the Fulton County Jail. And Brian Steele is saying, look, and we already have a situation where we're overcrowded, right? So let's go on ahead and get your boy up out of there. He could be at the crib. He could be jailed at home. Let me tell you something. As a person who's been on probation before, let me tell you something. Probation is literally jail outside. You ain't really gonna be doing much of anything. I'm telling you right now. You think you think you can sneak around to do something? No. It ain't cut like that. Trust me. And you have to meet with your probation officer all the time. You got to drop randomly. You can't go to certain places. You can't drive at a certain time at night or a certain time in the morning. If you do work, you have to have restrictive licensing. You have to prove your work. You have to prove the time that you work. And within that time frame from when you go to work, get up for work, and get off work, you can only drive in that time frame. After that time frame, you can't drive no more until the next morning. Probation is jail outside for real. So this home confinement is real. Okay. The legislature found that electronic release, monitoring, and home confinement incorporates modern technology to accomplish various purposes. Therefore, our General Assembly explicitly recognizes that Mr. Williams' home is a place where he could be confined and restricted in movement for the purpose of electronic pre-verdict release on bond. Ordering Mr. Williams to wear the ankle monitor and to be in total lockdown, quote unquote, in his home is the equivalent to custody and confinement and has been deemed lawful confinement without the punishment imposed by the current county jail conditions wrongly imposed on Mr. Williams. Okay, now I got to call a little bit of cap on this. When he said the home is the equivalent to custody and confinement, as he been deemed lawful confinement without punishment imposed, it by the current county jail, it ain't the same as being in jail now. No. it ain't the same as jail. Like that. Listen, it's confinement. Yes, you locked down for sure, but you still get to go in your refrigerator and eat whatever you want. You still get to cook whatever you want. You still get to do certain things that you can't really do in jail. So it's not exactly the same thing, but you still are confined. And even if you are in a place where you're in a confined space and it's a nice place, but you're still stuck inside, it still can weigh on you mentally a little bit. So some of that is a little bit of cap, I ain't gonna lie. But his embellishment is not far-fetched. So I gotta give Steele on that one. And DoorDash, look. Yeah, DoorDash. Yeah, you can, if you want to put DoorDash on that list or Uber Eats on the list, you can do that. You know what I'm saying? All right. Let's see here. Since May 9th of 2022, Mr. Williams endures the torturous conditions in county jail. That's facts. To wit, 22 out of the 24 hours a day locked into a small cement cell with no contact with another human being except when his counsel visits and in court proceedings. Inedible food. Oh my God. The food in jail is terrible. Horrible. The absolute worst. Living in squalor and infested rooms and unable to see any activity movement out of the cell's windows. My God. Oh man, we talked about the conditions here on this channel. All right. We did highlight that on a live. I forgot which live it was. Somebody help me out and correct me. But we talked about the conditions of the Fulton County Jail and how horrible it is. And we looked at where the money is going. You had 36 point something million dollars in the Fulton County Jail alone. Fulton County alone. The state of Georgia had a $1.2 billion budget. Fulton County got about 36 million of those monies. And the jail renovation was supposed to be one of the first projects they worked on. And they have ants, bed bugs, all kind of craziness. Men in there with shanks. They're killing each other in there. It is horrible conditions in the Fulton County Jail. All right, number 3 here says Mr. Williams is not a significant risk to commit a felony while out of bond. Mr. Williams is not a convicted felon. Now, I want you to keep this in mind. He doesn't have a prior, all right? And neither does Mr. Huey. We found that out during the Silver Fox opening statement. So we want to highlight Silver Fox today. We're going to highlight him in a minute. Mr. Williams is not a convicted felon. This fact alone satisfies this bond factor. Moreover, law enforcement officers executed a search warrant on and about Monday, May 9, 2022, after the arrest of Mr. Williams on the original grand jury indictment, an incident to search drugs and guns were allegedly located in this home. At the time of this search, there were numerous people at and in Mr. Williams' home. So in other words, anybody could have slipped something up in there. This is because others live at this home more often than Mr. Williams, who is at this home intermittently, as Mr. Williams has several homes in the Atlanta area. Thus, Mr. Williams is not a significant risk to commit a felony while out on bond, especially with the use of security and other conditions offered above. See, this is the offer. So since Mr. Williams is not a significant risk without a crime, to commit a crime, he is also not a significant threat to the community, property, or person in the same. The last but not least one, Mr. Williams is not a significant risk to intimidate witnesses. Mr. Williams has suggested as a condition of bond that all of his calls, texts, and other means of communication are monitored, saved privileged communications, and additionally, he will be secured in his home when not present in court. This will prevent any possibility to intimidate a witness or any possibility to obstruct the administration of justice via electronic means. In today's times, the legislature has provided that ankle monitors are a humane method of incarcerating a criminally accused without the need for punishment that is endured by languishing in the county jail. This honorable court's foremost consideration with fixing the amount of bail should be the probability that Mr. Williams, if granted bond, will appear at trial. And he's already saying that he will. It's a high-profile case, so of course he's going to come to court. Mr. Williams is a respected, high-profile artist who has positively impacted lives of others who would otherwise never break the poverty line. And that's an interesting thing, too. I mean, if we actually be honest here, look. Young Thug gave guys opportunities. He really did. He has. That's just a fact. He has done that. Okay. He has given guys opportunity to be artists or to be producers or whatever the case may be. Even if he had, and let's say, for instance, allegedly all of this is true, that what he's done. The way that the state is trying to pursue this is totally off. It just is. It's just totally off. So this is another reason why people are like, man, this corruption is being highlighted in so many levels based on this trial, So, but for him to, but he is not going to do anything to break this poverty line here. Again, he have given people opportunity, including Lil Woody. And Lil Woody even said on Caleb Bumpus' live on her channel that Thug was a good person. He said out his own mouth. So Mr. Williams has made a tremendous positive impact in our community. Mr. Williams is a positive member of society. He will continue to lawfully and ethically fight these baseless charges. Governed by the above facts and law, Mr. Williams satisfies all four prongs of the Ayala versus State Supra test. Says here, Mr. Williams satisfies these four bond factors, and thus the burden of production falls onto the prosecution. And the prosecution always retains the burden of persuasion that there are no conditions of bond that can be crafted to permit Mr. Williams to be entitled to pre-verdict release whatsoever. In our society, liberty is the norm. Custodial detention prior to verdict is carefully limited to few people. It says here, indeed, the most important element of liberty is to be free from physical detention by one's own government. Based upon the above, Mr. Williams must be granted a reasonable bond with conditions of the same. Wherefore, Mr. Williams respectfully requests a reasonable bond be set by this honorable court with reasonable conditions of same. And it's over here stamped by your boy Steele, and he also have the certificate of service included as well. So what do you all think about this? And what amount of money would you give? What would you set the bond as? You know, what would you set the bond as? What would you set the bond as? You know, would it be $1 million? Would it be 250,000, 300,000? You know, I think $1 million reasonable. You know, especially with all the conditions and the significance of the charges. Reasonably, you know. I mean, he'll be able to do it because $1 million was like 10% or something like that, right? Abundance said, I think a bond should be at $1 million. I mean, yeah, $1 million, 10%. Yeah, he'd do it today. 10% surety. Yeah, he'd do it today. He would do that today. Easy peasy. Snap of a finger, right? We talking about Young Slug. We talking about Young Thug, Young Slime. All right. So I wanted to talk about that. That's a very interesting. I mean, that offer that Brian Steele gave really is not bad. I can't say that. That's not a bad offer at all. And he's not a prior convicted felon. He doesn't have any priors at all. You know, when I was facing my criminal misdemeanor charge, I never had a criminal misdemeanor. What I did was a first offense. So the magistrate let me go and gave me a court hearing, you know. And then when I got to the court hearing, I had my lawyer and they submitted again, I told y'all, they're going to give you a plea deal, especially if there's evidence that you did it, you know. And there was evidence that what I did is what I did. So it wasn't no denying it. But I was able to negotiate the plea deal when it came to my licensing and things like that, because I do work and I have a hybrid position. I'm an IT professional, so I can work from home and on site. So I needed that flexibility. And so they were able to do certain things for me. But again, you don't have to always take the first plea deal that they give. You can negotiate your plea deals. You know what I'm saying? So, yeah. Now, remember, we have also put it this way. This case here where Marquavius Huey want to get his bond renewed. Okay. And this is where it was either for a renewal of the motion for bond or a motion for mistrial, or either both. All right. And so it was based on the fact upon the circumstances had changed. And there was a motion for a bond for him before, and it was denied. It was denied. All right. And so the same thing with Marquavius Huey is that he did not have any prior convictions either. All right. We're going to figure that out. We're going to find that out in the video that I'm going to play, where we're going to highlight lawyer Matthews, the defense attorney for Marquavius Huey. I never got a chance to saw his opening statement. I never got a chance to see anything. I mean, has anybody in the chat ever seen his opening statement? I don't remember seeing it at all. This case has been going on for so long. We've been overlooking a lot of different things to highlight, you know. So the background of this whole situation is the fact that Huey was booked in the Fulton County Jail in 2021 and remained in continuous under uninterrupted custody without bond since that date of his arrest on the grand jury bench. He petitioned this court, this actual court, Judge Whitaker, this new judge, this court, for bond on September 8th of 2022, and it was denied. Okay, it was denied. And so again, the same things. He doesn't pose a threat or a flight risk. He's not a significant risk or a threat to the community or to any person. He's not at risk of committing a felony pending trial. And again, poses no significant risk, intimidating witnesses or anything of that. It's the same four. So it's basically the same thing. And he's saying, look, the circumstances have changed, and I need for you to reconsider this for real. All right. I need you to reconsider this. Okay. So we're going to go ahead and look at Marquavius Huey's attorney, Careton Matthews Sr., and we want to highlight him today. Okay. We want to highlight his skill set as a lawyer that represents Marquavius Huey, and see him in full action of his opening statement. And this is day 2 opening statement of Mr. Careton Matthews as he makes opening statement for Marquavius Huey before the actual jury. All right, here we go.
Good afternoon, ladies and gentlemen. You guys just need to stretch or anything. My name is Careton Matthews, Sr., attorney Teresa Mafood, and attorney Careton Matthews, Jr. We have the pleasure and the honor of representing Mr. Marquavius Huey in these proceedings. Who is Marquavius Huey? Marquavius Huey is 27 years old. He is 27 years old. He was born and raised in Atlanta, Georgia. Born and raised in Jonesboro South housing projects, as you have heard about over these last several hours throughout these various opening statements. He has 6 other brothers and sisters, and he actually graduated, ladies and gentlemen, from South Atlanta High School in 2014. He has 2 children. He has a 4-year-old son, Major, and a 1-year-old daughter, Journey. Mr. Marquavius Huey is not a convicted felon.
See that?
He can sit on a jury. He can own a firearm. He can vote. And he can do what other law-abiding citizens can do as a non-convicted felon. He has goals, ladies and gentlemen. He has goals of being able to
all right, Abundance, relax now.
open a store, a retail store that sells men's and women's clothing. It's one of his goals. And when he grew up in Jonesboro South, ladies and gentlemen, he grew up with various folks that live in that community. As any community that you live in, you gain friendships and you grow up together. And Mr. Huey, he grew up. He grew up with Jeffrey Williams. They were friends from childhood. That's what the evidence will show. You will learn it. Now, let's get into the overt act 76. This is a theft by receiving of a handgun in 2018. That's one of the overt acts in this case, ladies and gentlemen. Now, in that particular indictment, back in 2018, that actual indictment was brought by the Fulton County District Attorney's Office. They brought it in 2018 against Mr. Huey. Also in 2018, they reduced it to misdemeanor disorderly conduct. They gave him 12 months probation, and they agreed to that reduction. This table, this organization, this agency.
He called him agency.
Now,
look at this.
In 2018, they reached that agreement with Mr. Huey. Now here we are in 2022 when this case was indicted, and now in 23 when it's being heard, they're using the same charge that they initially charged him with, a theft by receiving of a handgun. They reduce it down to a little misdemeanor, disorderly conduct. And now they say, hey, let's tell the ladies and gentlemen of this RICO trial that this is an overt act in a RICO conspiracy in a YSL case.
Wow. Yo, that's crazy. That is crazy. Now that charge is now a part of the RICO conspiracy case. The charge that they agreed to, the charge that they agreed to settle, to do probation for it and reduce it to a criminal misdemeanor. They're using that same charge because that's a part of this RICO conspiracy. That is absolutely wild. That is absolutely wild. Yo. Oh, man.
That's what they have brought to you in this indictment. The evidence will show that in 2018, this had nothing to do with anything concerning RICO. Because the evidence will show, had it, now keep in mind, the dates 2013 to even the present is what the government just told you all yesterday, was this RICO conspiracy. So in 2018, ladies and gentlemen, if this particular overt act has anything to do with a RICO conspiracy today, why did the same agency decide in 2018 that a felony theft by receiving charge negotiated, agreed to, should get reduced down to disorderly conduct?
It's already kind of wow, man.
But this is what the evidence will show. You will learn it, and this is what's been handed to you. Now, let's break it down. This indictment. Counts 3 through 7 we're going to go through first, and then we're going to go through another grouping of counts. But there are a lot of charges in this indictment with respect to Mr. Huey. There are a lot of charges, right? But when these charges are put together the way that they are supposed to be, you will see as we get through this case that there are 2 cases that we're dealing with in these groupings, and then we're going to talk about another incident concerning the Fulton County Jail. So just stay with me. We're going to get there.
Okay.
Let's first talk about April 26th, 2019. These are counts 3 through 7.
What's Super Fox
Count
in the chat?
3, Overt Act 88. Mr. Huey is charged with armed robbery. They're saying that on April 26th, they're alleging that Mr. Huey, as a party to a crime, committed this armed robbery against this gentleman by the name of DeJuan Maynard. That's what that particular count talks about, an armed robbery, using a firearm with an unknown person to take these items from this person. We're going to get into details, but I'm going to go over the charges first. Count 4. They are charging Mr. Huey with Overt Act 89, aggravated assault, saying that with that same firearm that Mr. Huey pointed the weapon at Mr. Maynard as he took the items, and that this makes up an aggravated assault. That's the charge. Going over the charges, then we're going to get into what the evidence is going to show. That's count 4. Count 5, the same one case we're talking about, the same one grouping, aggravated assault, because there was this other individual by the name of DeMond Jenkins who was with Mr. Maynard. So they have charged Mr. Huey with this ag assault on the DeMond Jenkins. Same grouping, same incident, April 26, 2019. And then count 6 are these tag-along charges that you typically come when you get charged with an armed robbery. You're going to get an ag assault, you're going to get a possession of a firearm during a commissioned felony. That's how the government, that's how they indict cases. Those are the charges. We'll get into all that later, but these are the charges. We'll get into that at a different stage in this trial. But that's count 6, saying that Mr. Huey had in his possession this firearm when this alleged incident happened, where they are claiming that Mr. Huey was involved. We're going to get into it. And then 7 is that same gun charge against Mr. DeMond Jenkins. So that's 3 through 7, ladies and gentlemen. April 26, 2019. So what happened? Let's get into it a little bit. April 26, 2019, around 12:39 a.m. in the morning, at 741 Morosco Drive, Northeast, Atlanta, Georgia, at this apartment complex called Core Lindbergh Apartments. That's a stock photo of that particular complex. Now, here's the story. The story is that, and we're not disputing that this incident happened. We're disputing that Mr. Huey is ever a part of it. Mr. Huey stands before here. He signed an indictment and indicated that he is not guilty and he is innocent of these charges. And we stand here straight and we look you in the eye and we stand tall that Mr. Marquez Huey is innocent. So, April 26, 2019, you've got 3 individuals. They have left the apartment unit, and these 3 individuals are walking in the parking deck, right? They're walking to their car. 3 individuals. As they're walking to the car, these 3 individuals, they see 2 black males get out of a vehicle they describe it as a black Mustang with a temporary tag. So these 3 individuals, they're in the parking deck, they're walking to their car, and 2 other individuals get out of the car and they begin to chase these 3 individuals. There's video surveillance in the parking garage. You will likely see this video surveillance. It's the government's case, and they get to present their case however they choose. If they choose to show you a video, you will see it. Right? Now, let's talk about these 3 individuals that are walking from their apartment to their car. Damon Jenkins, he lives there. He knows the apartment complex. He knows the parking deck, right? So he lives there. He's familiar with his spot. He's familiar with his crib, right? So he runs down the parking deck. So he sees them. He's walking. He sees them. He goes down. So he goes essentially left. Okay? That's Damon Jenkins, the apartment lessee, the owner of the apartment, his crib. DeJuan Maynard.
His crib.
DeJuan Maynard is with Damon Jenkins, right? What does he do? So he's visiting his friend, Damon Jenkins. Damon Jenkins has the keys to Maynard's vehicle. Maynard is the one with the jewelry and the items, right? Maynard, he goes right, and he goes up the parking deck, right? And he's running. Now, you've got this armed robbery that has occurred. You've got Damon Jenkins going left, down the deck. You've got Maynard going right, up the deck. Now, pay close attention. The 2 perpetrators, they decide that they are going to go after one person, not 2, right? This is an armed robbery, right? You got 2 perpetrators, you got 3 victims. One of those victims goes left, Jenkins, Maynard goes right. Maynard is the one person out of those 3 that those 2 perpetrators go after. So you got 2 individuals that are the perpetrators chasing Maynard up the parking deck. The 3rd male, I guess he goes down, and he is not chased. He goes down. One goes left. He ducks. The other one, Maynard goes up the deck. The 2 perpetrators chase Maynard. That's the story. That's how it's happening. Now, the 2 perpetrators, they reach Maynard. When they reach Maynard, ladies and gentlemen, Maynard, He says when he got hit with, one of them hit him with the firearm, and that they took items. Now, these are the items that Maynard says were taken. This is what he says were taken. He says a ring, a diamond 5-point star ring. He says 2 gold chain necklaces, one with a cross, another with diamonds, 1 pair of diamond earrings, a gold Gucci bracelet, a SunTrust debit card, a Gucci bag, a Louis Vuitton bag, and some cash. So you got all this grouping of items that Maynard says that was taken from him. You've got police officers galore that come over to the scene, right? So you've got responding officers, you've got white shirt officers, you've got sergeants, everybody responding there, trying to figure out what happened. They talked to Maynard and Jenkins, right? They talked to the security guard, Joel Hines. Joel Hines, he says that, I was patrolling the area. I saw this black vehicle that had been parked and running for about an hour or so. It had tinted windows, and I couldn't see inside. And, apartment owners, sometimes they'll come sit in their apartment, in their cars before they go inside, so I didn't think anything of it. I didn't see anybody. I didn't get a look at anyone. So the security guard, he doesn't see any individuals that are in the black vehicle. They canvass the parking deck. The officers, they get surveillance videos from the parking garage. So that's what the officers are doing. That's what they did that night, right? Now, here's where it gets interesting, ladies and gentlemen. On April 26, 2019, at 12:39 in the morning, that's when this incident happened. Demond Jenkins, when he goes left, Demond Jenkins, who's the apartment owner, when he goes left, he goes downstairs, he runs out, and he happens to see an officer, he flags him down. So that officer's right there, pretty much. All right? And then other officers start coming and converging on this incident scene to try to figure out what happened. But on that same day, later that day,
Oh,
Maynard,
that right there is emphasis, yo. Later that day. All right, let's not get it twisted. That is, first of all, put a 1 in the chat if you love Silver Fox right now. For those that's just coming in, we just found out that Marquavius Huey had a charge for a gun in 2018, he said, or 19. And that charge got reduced to disorderly conduct, and he was on probation for a year for that. Now, what the state is doing is taking that charge and implementing it inside of the RICO conspiracy case according to its timeline. You see what I'm saying? So what they're doing is they trying to charge him again for something and include it in the RICO conspiracy that was once just a different charge that he already took a probation plea for. This is what we have. This is what Marquavius Huey is charged with. This is the reason why he did not take a plea, and this is the reason why he is fighting for he's going to trial, because it's not included in the RICO conspiracy case. So that is what's going on right now. All right. So just want to let everybody know what's going on. All right, let's go.
Demond Jenkins, when he goes left, Demond Jenkins, who's the apartment owner, when he goes left, he goes downstairs, he runs out, and he happens to see an officer, he flags him down. So that officer's right there, pretty much. All right? And then other officers start coming and converging on this incident scene to try to figure out what happened. But on that same day, later that day,
That's right.
Maynard, the one whose items he claims were taken, he does this. I don't know if he does an internet search, what he does. How in the world of millions of social media people that are on social media, Instagrammers, people that have pages, Maynard calls into zone 2 and he tells the police that he just happened to be scrolling Instagram and he saw a person wearing his diamond 5-point star ring.
Oh, crap. Oh, later that day, he all of this Instagram stuff and found out that there was someone else. Someone else was wearing that ring. This is the opening statement, ladies and gentlemen, of Careton Matthews Sr., aka the Silver Fox. Let's go.
Millions of social media people that are on social media, Instagrammers, people that have pages. Maynard calls into zone 2 and he tells the police that he just happened to be scrolling Instagram and he saw a person wearing his diamond 5-point star ring. Imagine that. Less than hours. So what does he do? Maynard calls in. You will hear evidence that when he calls in, that he sends some photographs. I'm going to get to that. So the case is assigned to Detective Jeffrey Henderson on April 28th, 2019. So the case now has a detective. A couple days later.
Wow. Okay.
Detective Jeffrey Henderson now has this case. What does he do when he gets the case? Well, he gets Maynard to send him these photographs. He views the video surveillance footage that he obtained from the parking deck, from the apartment complex.
Okay.
And he asks him to send some pictures of the jewelry. So send this information that you found on Instagram, send me some pictures of your jewelry, and send me some videos, and let me take a look at the video surveillances that I was able to get from the parking deck. So these are the photographs that Maynard, the victim in the case, he sends Detective Jeffrey Henderson 2 separate Instagram pictures of 2 separate people. On the left there is a picture he sends of someone else, some person in the world on social media. Maynard sends that photograph, and he sends the one on the right. The one on the right is Mr. Huey's Instagram. The one on the left is someone else's Instagram. He sends these to Maynard, to the Detective Henderson.
Yeah, cameraman. Shout out to the cameraman.
With the same ring, or the similar ring, or some ring that looks like the one that he owned.
Wow.
The same day. So he becomes his own detective. Now, the video that was obtained from the parking garage, ladies and gentlemen, that video, it shows the 2 perpetrators running after Maynard, right? One of those perpetrators has on like a black jacket and maybe some red pants or something of that nature. The other person has on a gold puff jacket and some black slacks, pants or jeans or whatever. So that's what the video is showing from the parking garage. So what does Detective Henderson do? So he goes on to Mr. Huey's page, and I guess starts scrolling Mr. Huey's page, Oh, Mr. Huey has a gold puff jacket. But guess what, ladies and gentlemen? In this particular, Mr. Huey's is on the right, standing in front of a black Infiniti vehicle that belongs to his lady, Justice Woodard, who is the mother of their two children, Major and Journey. On the left is a photograph. You heard Mr. App talk about that huge discovery that was sent to us. The evidence will show that that particular photograph is part of the discovery that came to us in this pile of evidence.
Wow.
That is a part of this case.
Come on, Silver
On the left are two young men. And what's interesting here, ladies and gentlemen, is that apparently that year, the gold puff jacket from Zara was a very popular item for young people as part of their wardrobe. We know that because you're going to learn that this is what was sent to us, and that is what was going on with the dress back in 2019. 3 different people with the same gold puff jacket that was provided to us in discovery, that the government provided to us.
The state provided evidence against their own charge against Jesus Christ. You gotta be kidding. You mean to tell me y'all submitted evidence that literally contradicts your accusations against the defense? Oh my God, man. I've been saying it for a long time. The state made a huge mistake in calling this RICO. I said it on the lead attorney's channel. This is nothing but some street beef. Okay. And they're trying to put a RICO charge on some street-ish. The fact that you submitted evidence to the defense that literally contradicts the charge that you're putting on Mr. Huey is absolutely insane. Providing that, I mean, is there evidence? The evidence, the burden of proof is always on the prosecution, remember? Is there evidence?
So the gold puff jacket is relevant here. Why? Because what was Detective Jeffrey Henderson's investigation at that point? Maynard sends him these 2 hands with the similar jewelry. Maynard sends him a piece of jewelry of his own to say, hey, you know, this is what was one of the items that was taken from me. And the video, ladies and gentlemen, from the apartment complex shows a person with that similar gold puff jacket. And what does Detective Jeffrey Henderson do with that information, ladies and gentlemen? He completes it. He completes his investigation.
What?
This happened on April 26, 2019.
What?
4 days later, he gets warrants for Mr. Huey's arrest on that investigation.
Wow.
That is the case.
Wow. He completed his investigation and still arrested Quay when the evidence showed contradiction. Jeez. Oh my God. Who is that detective? He is, man, look. Somebody's career is not going to be good. Okay. This is crazy work. This is nasty work. This is nasty work.
Now, there is no photographic lineup that was ever done. Maynard never says he saw Mr. Huey that night on April 26, 2019. They're not wearing masks. Mr. Devon Jenkins never selects Mr. Huey out of any photographic lineup. In fact, there was none done. There was no photographic lineup performed or attempted to be performed by Detective Henderson for the benefit of Maynard or the benefit of Jenkins in this case.
Wow, dude.
He took what he got from that video surveillance, went on to receive the information that Maynard sent him, and decided that there was enough for a warrant. No photographic identification, no fingerprints left at any of those scenes.
Come on now.
No shell casings that are linked to any firearms belonging to Mr. Huey. None of it.
Media cops.
That's what you're going to learn.
Social media cops.
You're going to learn, ladies and gentlemen, that at any arrest that was made against Mr. Huey, any arrest that was made against Mr. Huey with respect to these items that Mr. Maynard says were taken from him, a gold 5.5-star ring, these necklaces, these items that we're talking about here, the Gucci, the Louis Vuitton, the debit cards, none of those items have ever been found on Mr. Huey's person, on Mr. Huey's any car, in any residence. None. That's the state's case for those grouping of charges, ladies and gentlemen.
That's crazy.
No DNA. Detective Henderson didn't even, when they arrested Mr. Huey for those particular charges, those groupings of charges, he didn't come down to the jail and even pull him out of the cell and say, hey, I want to talk with you. Are you willing to talk with me? Of course, that's Mr. Huey's right to either talk to him or not talk to him, but he didn't even try.
Dang. Silver Fox in the building.
No other witnesses out there at that location that are going to tell you that they ever saw Mr. Huey at that location.
Exactly. How is this nigga?
That's what you're going to learn about that grouping of cases. No photographic lineup. Ladies and gentlemen, this is interesting. Listen to me very closely. You will not hear any evidence of a cell phone tower locating Mr. Huey at 741 Morosco Drive, Northeast Atlanta, Georgia. You will not hear it. In the technology-driven world that we live in, cell phone evidence is powerful in terms of being able to put people at locations. Ask me, did Detective Henderson make any efforts to do that? You will learn the answer is no.
Woo! Listen. Look, Julie said this is a great reminder of how weak the state's case is. This is the reason why I wanted to highlight the Silver Fox. Team Silver Fox. Everybody put Silver Fox in the chat right now. Put Silver Fox in the chat right now. Let him cook.
Okay, that was that grouping of cases, ladies and gentlemen. Okay? That was that case from April 26, 2019. Okay?
2019.
Now let's move on to this other grouping of cases that we just, that I want to talk about now. So let's move on to another time and another place. Let's go to October 1st, 2020.
Let the man cook, y'all.
Now, count 14, when you all get this indictment, count 14 over Act 116 charges Mr. Huey with armed robbery, alleging that Mr. Huey and another unknown person committed an armed robbery against a gentleman by the name of Gary Holloman. That's what count 14 says, by use of a firearm. That's 14. 15, we're still on October 1, 2020. These next series of counts are going to deal with one day. This particular count, 15, armed robbery, says that on that same evening, that Mr. Huey, along with this unknown person, committed this armed robbery against Domisha Coppage, who is out there with Gary Holloman at an address that we're going to get to in just a moment. But I want to go over the charges first, and we're going to get into the facts in a moment. So that's the charge right there. Count 15, an armed robbery concerning Domisha Coppage. Count 16, this is a big case, ladies and gentlemen, so I'm giving you an opportunity to try to organize it as best you can. Because we definitely have been learning all year how to organize a big case.
Shout out to my mom, y'all.
Count 16, aggravated assault with a deadly weapon. Like I said, whenever there's this armed robbery allegation, it's going to come with a host of other counts and charges tagging along with it. Because that's the way the state and government, that's how they do it. That's how they get down, and that's how they do it. That's their right, and that's how they want to bring it. But we're going to talk about it. Count 16 alleges aggravated assault. So whenever you commit an armed robbery, then you've got a firearm, then you're going to get an aggravated assault charge with it. That's the aggravated account charge that deals with Gary Holloman. That's 16. 17 deals with Domisha Coppage. 18 is another way of alleging an armed robbery. When you specifically use a firearm to take this clicker out of my hand, that's armed robbery. But if this clicker were an automobile, and I was sitting in this automobile, and you use a weapon to demand me to get out of the automobile, it's an armed robbery, but they call it, it's a separate charge that's called hijacking of a motor vehicle. Basically, it's an armed robbery of a car or an auto, or truck or a vehicle.
There you go.
That's count 18.
Mm-hmm.
They're saying that Mr. Huey, along with this other person, took a 2016 Buick LaCrosse from Gary Holloman. That's 18. 19, again, whenever there's a weapon that's involved, they're going to tag along this possession of a firearm to the commission of, in this case, the ag assault with a deadly weapon and the hijacking of a motor vehicle. So you're going to get a possession of a firearm during the commission of a felony charge. Same thing with respect to Ms. Coppage. Armed robbery and an aggravated assault to take that cell phone that she's saying was taken. You're going to get a count 20, a possession of a firearm during a commission of a felony. And then what they've done is they said in 21 that this was gang related. So they tack on a criminal street gang charge.
They just stacking charges, man. They just stacking, bro. Stacking.
And the same thing for Ms. Coppedge. So those are the street gang charges that they've alleged. That's 23. So let's get into it now. So those are the charges, ladies and gentlemen. On October 1, 2020, 250 Fulton Street, Southwest Atlanta, Georgia. Not very far from where we are now, over by the juvenile court building. They're alleging that on this particular October 1, 2020, in the evening hours, that these charges that we just talked about occur. Now let's deal with it. What is being alleged here? Gary Holloman, who's no longer with us, ladies and gentlemen. Gary Holloman sold pills for a living. He was a drug dealer. And Mr. Huey had gotten injured. And his injury was the result of a shot to his leg and being out in the public and living in the area. There was a shooting incident. He got shot. Okay? When he got shot, he ran out of the ability to get medicine the right way. So what did he do? He found that this guy Holloman that he knew through this other person, Mender, that Mr. Holloman sold Percocets. So what happens? He had been dealing with Mr. Holloman for some period of time. You're going to hear about it. And how do you know you're going to hear about it? Because when Detective Henderson comes into this courtroom and sits in this witness stand, I'm going to ask him questions about it. Now, Huey knows Gary Holloman because they had been doing business. Mr. Holloman purchased 2 or 3 pills periodically, $20 a pop, Percocets. And he dealt with Holloman various occasions. Nothing unusual. I'm going to meet you. I'm going to call you, right? He calls him. Huey calls Holloman from time to time, right? And when he calls Holloman from time to time, Holloman, in fact, you will learn through Henderson that Henderson, when they arrested Mr. Huey on these charges, they sit Mr. Huey down in an interview room. And when they sit Mr. Huey down in an interview room, Henderson reads him his rights. And Mr. Huey agrees to talk with him without an attorney. Because I don't have anything to hide. I'm okay talking to you without a lawyer. He sits down, talks to him. And Mr. Huey, he didn't know specifically why he was even being arrested at that moment. And you'll hear about it, right? And when you hear about it, Henderson is saying, hey, somebody's saying that you carjacked him. Okay, tell me about it. What are you talking about?
Right.
And then Huey and Detective Henderson, Huey says, okay, so you're talking about the streets been talking. The streets been talking. They saying that I set Holloman up. They saying I set Holloman up. I didn't set Holloman up. I deal with Holloman. I didn't set this man up. Holloman chose this particular location for us to meet, and we've met before. I know this man. In fact, now here's where it gets real interesting. In fact, Huey says to Holloman, to Henderson, Detective Henderson, you can look through my phone. So, Henderson looks through the phone. And what does he see, ladies and gentlemen? He sees
Your Honor, we're going to object to this portion of
Basis.
self-serving hearsay.
Yep, the evidence will show.
I'll overrule the objection.
Yeah.
Be quiet, Hilton. Be quiet. Let the man cook. Let the man cook.
Will show, ladies and gentlemen, that Henderson, they have the phone out. Huey is leaning over. Henderson has the phone. They're scrolling. Okay. But the warrant had already been written up. He was in jail. He was arrested that night. He was being arrested for it on the 24th of November, 2020. But Mr. Huey shows Mr. Henderson that he and Holloman had a relationship. You got something I want. You got something that I want to get. Some Percocets. They're available. That was our relationship, right? Now, that's what Huey says to Henderson, and is corroborated in a phone that belonged to Mr. Huey that Henderson was allowed to look at on that particular morning when they arrested this man. So that's what came out from Mr. Huey. Let's talk about what came out from Mr. Holloman when he called 911. So what does Holloman basically say in the 911 call? He says that I just got robbed, and he says my nephew homeboy robbed me. My nephew's homeboy robbed me. That's what he says. And I was meeting with him because my nephew wanted me to give him some money to put on my nephew's books at the Fulton County Jail. That's what Holloman says to 911. Now, you're going to ask yourselves, ladies and gentlemen, the evidence is going to show that you don't need to give money to your nephew's homeboy to put on your nephew's books at the Fulton County Jail. The evidence will show there are many ways in which you can put money on somebody's books at the Fulton County Jail instead of giving money to your nephew's homeboy.
Exactly.
So you are going to have to reconcile that story that my man Holloman told 911. And in the 911 call, he didn't say, that's what he said. My nephew's homeboys, I'm putting some money giving money to giving some money to my nephew homeboy. That's what he said. So you're going to reconcile those. You're going to have to balance those two versions of events. You're going to have to ask yourself, and here's the other thing you're going to learn with this same case. You're going to learn that Mr. Holloman tells Mr. Henderson that Mr. Huey didn't have a firearm. And he's going to say, whatever he's going to say, from my understanding, is somebody just walked up out of the dark and put a stick on him and took his car, not Mr. Huey. What is Delmisha Coppage? Delmisha Coppage, you're going to learn that she actually lived at 250 Fulton Street, right? And that Mr. Holloman was there to meet her, right? And you're going to learn from Delmisha Coppage, if they decide to call her as a witness, that they interviewed Delmisha Coppage in September of 2022, shortly after they indicted this case that we're here today on. They decided to go out, do their field interviews of their alleged victims and talk to them. In September of 2022, Delmisha Coppage tells Officer Investigator Viverito, she tells this law enforcement person that, they took BG's car, Gary Holloman, BG. They took BG's car, and they also took my car. So the other one left in my car. You will hear that.
Wow.
And there had been no information, allegations of her car ever being taken on October 1, 2020 until September 22nd, 2022, when she told it to Investigator Viverito. Mr. Hughes is not even charged with taking Delmisha Coppage's vehicle. Why would she say something like that? So you all, as the triers of fact, fancy little phrase that we use in the legal business, you all, as the deciders, will have to determine with whom you will believe. What is the credibility? So those are things and decisions that you will have to make. But her car was never, ever taken. These are the items that were claimed that had been taken: a Buick LaCrosse, Kerry Holloman's cell phone, Delmisha Coppage's cell phone, and Mr. Holloman tells him $10,000 in cash. You will be assessing the credibility of witnesses throughout this case. For each of these wrongfully accused individuals that are seated at these tables. Now, witnesses are going to come into this courtroom, and they're going to sit right here. And you'll see me. You may see Attorney CJ. You may see some of these other lawyers. We're going to be standing right here, ladies and gentlemen. And we're going to be asking them questions on the witness stand. And they have come into this court and raise their hand, promising to tell them God's honest truth. And when we get them into this courtroom, and when we cross-examine them, and we bring it out and establish certain things, we're going to come back to you, and we're going to tell you why, when we set this in opening, that this is the way it should go. let's change gears. One last gear, few last gears to change. I know it's a long day, we're getting there. Now, ladies and gentlemen, let's move to a different day and time. So that was that case. So we have covered counts 3 through 7 for an April 26, 2019 situation. We have covered, and by the way, before I get into this, let me back up one more step. No vehicle cross was ever found in Mr. Huey's possession. No cell phone was ever found in Mr. Huey's possession belonging to Demisha Coppage, Gary Holliman. And in fact, there's technology out here, ladies and gentlemen, where these smartphones, these iPhones, they stay on, right? You can track these bad boys. We're gonna be asking questions down the line. So when I'm up standing and cross-examining and talking to these witnesses, pay very close attention to, that technology, these smartphones. What did Detective Henderson do to follow up?
Mr. Matthews, I hate to interrupt your opening remarks. Can we take a brief comfort break? How much longer do you have, sir?
Oh, really? So that was the end of that video right there. Listen, shout out to the Silver Fox for sure. Hold on, let me see if I can get part 2 of this video. I don't see it anywhere. So they used an old charge to include in this RICO case on Marquavius Huey. They found the evidence that was given to the defense came from the state that contradicts the actual charge that they are placing on Marquavius Huey. They're trying to take an old charge and bring it to a current case because they don't have any evidence in the current case to actually back up that charge that concerns RICO conspiracy. Unbelievable. I am so glad that we highlighted the Silver Fox. Shout out to the Silver Fox once again. Shout out to the Silver Fox once again. Yo, what y'all thinking on this, man? This right here was absolutely crazy. This right here is absolutely crazy. Well, listen, this is the reason why he's saying that with the motion that we read, this is the reason why he's saying, look, you need to reconsider this under the circumstances that have changed. And based on the fact that it's been since 2022 that you denied this motion for a bond, most certainly at this point, considering all the ex parte, considering all of the things that happened where you saw Brian Steele get held in criminal contempt in court in front of the clients. You saw all of this happen and take place. Chief Judge Glanville has been recused. Judge Ingram recused herself. Judge Krause granted all the motions and denied the motion for denied the whole motion against Caleb Bumpus. All these circumstances have now changed. Now it's time for you to reconsider my client, Marquavius Huey, based on the fact based on the fact, shout out Abundance said, I think the case should not be classified as RICO case for sure. Absolutely. This is the mistake that they made. The mistake they made was calling it RICO. You can't take street beef, some Negroes who got beef with each other in the street, who done slid each other a couple bags of weed here and there, or whatever the case may be, or a couple, what do you say, Percocet and all that, whatever it is, a couple pills, and call it RICO. You acting like they got full contraband. You acting like they got a bunch of illegal substances just lying around in a storage room somewhere where they can go collect it, like they did in the mafia days, like they did in the cocaine days. Y'all acting like this dude is Nicky Barnes. Y'all acting like he Frank Lucas. Y'all acting like he the Chambers brothers. BMF. No. You found there's one gun, one firearm that has been placed in evidence in this whole case. One. This is why they're trying to bank everything. They're trying to bank everything and surround everything that's RICO. So they're trying to do it around one thing, and that is the death of Mr. Donovan Thomas. They don't have any gun. They don't have any type of gun. Like they're moving illegal guns. They're not doing none of that. They don't have a gun operation. They don't have a drug operation that they actually uncovered. They don't have anything. Silver Fox single-handedly in the opening statement exposed how weak the prosecution's case is. And then when Hilton tried to object the opening statement, it got overruled. Because all he did, this is the genius of this man. All he did was repeat the evidence that you gave him, put it in a PowerPoint presentation, and smushed it in your face and made you look goofy at your own case. I'm definitely going to clip this and I'm going to premiere this. So those of them that have not seen this live, they're going to see this. They are going to see this. You're trying to make a case and trying to use an armed robbery that got reduced to disorderly conduct. And then not only that, you placed a probation on this man for 12 months because why? He said it in the beginning. He's not a convicted felon of any sort. He doesn't have any priors that can equate to him not receiving a bond. So, since my client has not received the bond and my client is going to trial on opening statement day, I'm going to expose you. That was day 2 of the trial. The Silver Fox destroyed the case of the prosecution and the DA's office single-handedly in the video that we just saw. Single-handedly destroyed the case. I am so glad that I had not seen this whole opening statement of the defense, of all the defense attorneys. You know, I know Max Sharp did his and all that kind of stuff, but the Silver Fox, I'm like, we got to highlight Silver Fox, man, because we've seen him cross-examine a lot of witnesses. And again, you know, this trial has been going on since 2022, 2021, 2022, whatever. Like, this has been going on for a long time. So obviously, everybody's not going to see everything. Okay. But one thing that we can say, based on what we just saw, there is absolutely no way. There is no way that a motion to not either renew or reconsider bond and or mistrial should be denied. Not after seeing this opening statement and not after seeing what has progressed since the beginning of this trial. Since the beginning of this trial. Okay. So next Tuesday, we're going to see Judge Whitaker, 8:45 a.m. sharp. I'm going to have it live on Tay-Biz TV. All right. I know it's going to be early. I'm not expecting a whole bunch of people to be in attendance, but I'm telling you one thing. Next Tuesday, we are going live about this. I want to see how she ruled in these motions. Tuesday might be a long day. Tuesday might be a long day. All right. Tuesday might be a long day. I appreciate the chat. Look at here, man. You know, my mom said stepped in and said, yeah, that's a bad silver fox right there. I want to highlight again what Julie said, social media cops. That was absolutely hilarious. Yo, so for those people who are watch this live later on and endure it all the way through to the end, go ahead and leave your comments. Leave what you think in the chat. Like, again, sometimes now that the case has gotten to this point, it's good to go back a little bit and see like how these things came to be. And what I just saw the Silver Fox do was absolutely insane. So BizNation, we're going to stand up, man, until next time. Look, I'm definitely going to go live again. I'm thinking about probably going live again, maybe tomorrow or maybe on tomorrow and Friday, just to highlight some of the defense attorneys, maybe do some highlights of, Brian Steele or Doug Weinstein or something like that and see what's cracking. But in the meantime, in between time, go ahead and like this video, share this video. Let me know what you think in the comments. Those that are watching this live after the fact, we're gonna see what happens. But until next time, it's your boy Tay Biz. I'm gonna holler at y'all in a minute. Hey, yo, keep your head up. Peace.
I brought that with me. Case they get too big. Baby, don't stress, don't sweat it. Put it all on my daddy. Know how I'm coming. And they know what we had. Run around through that left side, low end. All of mine need more wins. If you got beef, don't come out. Cause my young hitter might go in. Uptown GN. Working all through my weekend. Hoping these don't show out. Cause all of my hitters too deep in. With a boy, I'm so ashamed. Ain't worried about long as my money and my green. Baby, I ain't got work tomorrow. Tell me what the business is. Ain't about no club hop. I'm trying to start some businesses. Shorty, you thought it was, they better know it's not that. Talking all that online, they knowing that it's not fake. Sliding through my hood, I make maneuvers like a Uber, baby. Got a 10-year plan, these can't tell what they doing lately. And I'm way too clean, I'm Listerine, I thought they been knew it. All in my lungs, I got my red cup full of that Henny fluid. Young middle Mac, I'm swinging that leg, I'm banging that do or die. And I ain't that Lily before I get crucified. Living in my bloodline, this place in my family tree. How the they pressed, I did my best out of what they handed me. Straight out of that country, know my shawty dick as human air. And I need not mention no extensions, that's human hair.